Good evening and welcome to Legal Talk, the talk show brought to you by the law offices of O'Donnell, Weiss and Megay. Your life, your business, your life, your law firm, excuse me. We're at 41 High Street in Pottstown, 347 Bridge Street in Phoenixville, and we're at owmlaw.com. Thanks for joining me tonight. My name's Dave Megay, and I'm an attorney with the law firm and have been for quite a few years. And I'm joined here tonight by one of my partners, Jim Kovaleski. Jim?
Hi, Dave.
Thanks for joining me.
Absolutely.
Folks, Jim and I are going to talk to you tonight about, well, first, show of hands, who are landlords out there? Who are tenants out there? We're going to talk about landlord-tenant issues, but Jim and I are going to talk about it not in the residential context, Jim, but we're going to talk about it in the commercial context. Who of you folks rent commercial space to run your businesses? Which of you folks are landlords who own properties in which tenants run commercial operations? And Jim, everything from retail to manufacturing. Folks, we're talking about those of you out there who own retail office space, storefront space, as well as Jim, commercial facilities like either raw ground or I'm looking for the W word, warehouse type space. So folks, tonight Jim and I are going to talk to you about a handful, 6 to 8 points that you need to be aware of or cognizant of when you negotiate a lease before signing a lease. And if you've already signed leases, whether you're the landlord or the tenant, I want you to get a piece of paper and a pencil tonight and jot down some notes on these 6 or 8 points, because I want you to go back and look at those leases and talk to your attorney. And if you don't have an attorney, give us a shout, and we can help walk you through the leases and these points. So, Jim, what I'd like to do, and you and I have negotiated both together and separately, as well as many of our other attorneys in both of our offices, plenty of commercial leases. And you and I talked before the show, and we quickly came up with about 6 to 8 points. The first point I want to make, and I have a lease in my mind's eye, and I'm a commercial lease, and I'm kind of thinking through, what's the first thing at the top of the lease?
It's always the parties. Who's the landlord, who's the tenant. So,
right.
And you would be surprised how often that those parties might not be the actual parties that should be the landlord or the tenant. Yeah,
actually, I wouldn't be surprised. Maybe these folks will be surprised, but it happens a lot where one point, folks, of what we're talking about is you have a landlord, a client of ours who's a landlord, and they have a corporate entity, Jim, but they never put the real estate in the name of the corporate entity. Or if the real estate is in the corporate entity, the landlord signs the lease, John Doe himself.
Absolutely. I've seen that, and I've seen it where the tenant does the same thing. We go out and form a corporate entity for the tenant to operate their business in. They go out, and maybe we didn't negotiate the lease, and I take a look at the lease later, and sure enough, the tenant, rather than putting their corporate entity in as the tenant, they sign it individually. It's in their individual name, which can be a problem moving forward.
Yeah, it's a big problem because you've lost that protection if you're the tenant or the landlord for that matter, that corporate protection, and you're just sloppy, and it's usually a function of not stopping and thinking, talking to your professionals, talking to your accountant, and especially your attorney to make sure that you have the right name. Jim, what about when we represent a tenant and we see a proposed lease from a landlord and the landlord's name is ABC Incorporated? Do you then stop and do some research and look at who owns the property?
Absolutely.
Well, why bother? Because the landlord's name is ABC Inc. on the lease, so ABC Inc. must own the real estate.
Well,
there's a softball I just lobbed at you.
I appreciate that. I'm going to try and hit it out of the park. We'll see. Basically, number one, hopefully the landlord's not a bad guy and just made an honest mistake. Maybe he has 3 corporate entities owning 3 separate properties, and he put in ABC instead of BCD, which is the one that owns this property. So it could just be an honest mistake. Sometimes it could be that the guy's a bad guy in the sense that he's trying to maybe rent property that he doesn't own or he doesn't have the right to rent.
Right.
So the tenant signs it, might give security deposit. They might find themselves out that money and chasing after this bad guy who was not really their landlord.
That's a great point. And even if it is an honest mistake, I've done this on behalf of tenants before. I've questioned why the landlord is ABC Inc. when I've done my research and the property is owned by XYZ Inc. And oftentimes the landlord will say, "You're right, I messed up. That's on another. This is a lease that I use on all my properties, and it was for another property. Sorry." And you get your client, the tenant, instant credibility then.
Absolutely.
Because then the landlord knows that the client is not just some schmo who's not paying attention, that he or she or it has the proper professional representation, and it's keeping their eye on the ball.
Yep, I think it sets a good stage, which is what I think you're saying.
Good. Let's talk. You mentioned something again a second ago, I should say, and we didn't talk about it, you and I, before the show started. The next thing I want to talk about, lease term wise, is security deposit. Yep. Is it as simple? It's as simple, I think, as if I'm the landlord, I want as much as possible, and if I'm the tenant, I want as little as possible.
Yeah, it really is. I mean, with most of these terms that we're going to talk about, if we go too far one way, it's going to favor the landlord. If we go too far the other way, it's going to favor the tenant, and the security deposit is one of them. You know, standard is probably most of the leases I see is 1 month's rent, whatever that is. Sometimes it's more. Very rarely it's less. If it's more, there's a reason why it's more. Maybe there's no personal guarantee, which we'll talk about a little bit later, so that's why they're asking for more. Mm-hmm. But for most of the leases that I look at, it's going to be 1 month. That usually seems to be the standard.
Yeah, I've actually represented 2 tenants in the last 6 to 9 months negotiating fairly large commercial leases, and the landlord didn't ask for any security deposit. Shocked the heck out of me. I don't know why. I don't know if they just weren't paying attention. I certainly, as the tenant's attorney, I didn't raise the issue or point out their omission, but they didn't ask for any deposit, which was wild, and it gave us as the tenant lots of leverage.
Sure. For
future issues. Jim, you're negotiating a pretty big lease in the Chester County area, and again, another softball I'm lobbing your way because you didn't think about it. Your deal, I think, was 2 or 3 months security deposit, was it?
We started out with a 3-month request from the landlord.
Wow, that's a lot of money.
That's a lot.
Because it's a big space.
And it's a big
so
space.
Big space equals big rent.
Absolutely. I mean, it's not you're renting a little storefront in Pottstown or Phoenixville for $1,200 a month. So you're talking about $3,600. This is much larger than that. So the landlord was pretty adamant that he wanted the 3 months. We fought like heck to get it reduced. And we finally did get it reduced, and what we've agreed to is a 1 month security deposit up front at the signing of the lease, and then a second month's worth of security deposit, which will be due, but to help out my client in their cash flow needs at the beginning, that's going to be payable over time, so that the landlord gets a little bit more security. They'll have the 2 month security deposit. The tenant has to give that, but they've got a little bit of time to get into the business to get the cash flows going in order to help fund that security deposit. So it was a true negotiation and true resolution in the sense that the landlord's probably not happy, the tenant's probably not 100% happy, but we were able to reach an agreement.
And you thought outside the box to find an agreement, which is the most important thing in negotiations.
Yep.
Getting to Yes. There's a book out there, I think. You ever hear that book? Getting to Yes, I believe it is. It's called, about negotiating. In other words, I'll take a position, you take a position, and I can hang tight to my position till the cows come home. But if we don't get a deal, what good is that?
No one wins.
Right. So anyway, the next thing we want to talk about, guys, is the terms and renewal options.
Yep.
You want to make sure that your term makes sense. Is it year to year, or if you're if you, the tenant, are investing money in fit out? We'll talk about fit out here in a minute. You want a longer term so you can recoup your investment.
Absolutely. And there's oftentimes there's outside variables like franchise agreements. If it's a franchise, they usually want the franchise agreement tied to the lease so that the terms are the same. So you might have this third party that's influencing what term you really want to look at. So you got to pay attention to all these different variables when you're negotiating that. It's not just simple as it's 2 years or it's 3 years or 5 years or whatever it is. You got to really put some thought to it.
And also, if you're a tenant and you really expect to be here or be at this property for quite a while, running your business at this property for quite a while, don't you want to build in some renewal options?
Absolutely. Like we talked about beforehand, I think that really favors the tenant because what it gives the tenant is some security that you know that at the end of your initial term, whether it's that 1 year, 3 year, 5 year, whatever it is, you're going to have something locked in that you can just, if you meet the requirements, you just say to the landlord, I'm going to have this additional renewal option for another 2 years, 4 years, whatever the term is, and you're locked in on those rates, which is really
those rental rates.
Those rental rates.
That's important, because if you didn't put the rental rate in, you got a renewal option, but the landlord could jack the rent up, and it's in effect senseless or ineffective.
Exactly.
A nullity.
Exactly. But
Okay.
the reason it favors the tenant, though, is the tenant can look and say, well, the market has crashed and the market's down. The renewal option doesn't really make sense, so I'm not going to exercise that. Rather, I'm going to negotiate a new lease with the landlord for a new period of time based upon those more favorable rent rates. So it really gives the tenant some ability to step back, take a look at what's going on, and find out what's going to be the best option for them.
And plan for the future.
Absolutely.
Ahead of time. Good. Next thing we want to talk about, folks, is the different types of rent. If you're a tenant and you are looking at a commercial lease, you're going to see different rent. You're thinking, wait a minute, Dave, rent's rent. No, there's minimum rent, there's CAM rent, common area maintenance rent, sometimes called additional rent in these leases. What's that? What should the parties be looking for, I should say?
Absolutely. You want to know what's your estimated monthly full number to get all in for that rent.
If you're the landlord.
If you're the landlord, and if you're the tenant, you want to know what it is, because you want to know what the minimum rent's going to be. So that's going to be you usually see it as a per square footage, $15, $5, whatever it's going to be, depending on the type of space you're renting. But then you want to look behind it, because like Dave said, there's oftentimes the tenant's going to be paying a pro rata share of the common area maintenance for the property if it's in a strip mall, or the taxes, or the insurance, or various other things, water, depending on how the water is billed. So it really is important for the tenant to understand what each one of those things, in addition to that minimum rent, they're going to be responsible for. Oftentimes what I like to have the tenant do is get from the landlord last year's budget, 2 years worth of budgets, 3 years worth of budgets, so they can see what's going on, what the costs are over that time, and potentially if there's a risk to it, we'll even negotiate that other rent, other than that minimum rent, can only go up a certain percentage each year, so that the tenant knows at a worst case scenario what that additional rent is going to be. But it's very important to pay attention to all that, because sometimes, depending on if it's warehouse space or space that's not really developed, that additional rent can sometimes be even greater than the minimum rent.
Yeah, I was just looking at a lease I was negotiating a lease down in Center City, Philadelphia, on behalf of a restaurant tenant, and that CAM was more than the regular rent.
There you go.
It was pretty crazy. That's great. Good idea, looking at the last couple of years CAM for the landlord, or asking the landlord for the last couple of years CAM to see how that's gone up through the last couple of years. Jim, in the next minute we have before we break, let's talk about maintenance provisions in the lease as far as HVAC, roof, and snow, ice, landscaping, that type of thing.
Again, that's probably one of the provisions I negotiate the most. The landlord once the tenant is in the space, the tenant takes over for all those maintenance, repairs, even replacement issues. So if the HVAC unit that's servicing the space goes bad, the landlord wants the tenant to be responsible for replacing that, even though the lease maybe is only a 2 or 3 year lease, so it doesn't make sense. So you got to pay attention to that, and you got to negotiate. If you're the tenant, you want to try and push some of that, or as much of that as possible, back to the landlord. I usually try and cap the amount of repair damages. So if it's above, say, $1,000, maybe the landlord starts paying for that. But there's ways to negotiate that, but you just have to be aware of what your responsibilities are.
And also, doesn't that depend a lot on the type of space? If we're looking at a standalone building, the landlord's way more apt to get the tenant to pay for everything versus a strip mall.
Sure. With the strip mall, you might be responsible for the interior walls and then so that the landlord might take some responsibility for the roof and things like that. But each lease is different, so you got to really pay attention.
Yeah, because each space is different.
Yep.
And it's very important. We have like 10 seconds here, but it's very important that if you're a tenant, folks, inspect the property beforehand with professional contractors, because you're taking on some big responsibilities here, and it's not a good excuse to say after the HVAC goes or the plumbing issues pop or the sprinkler goes bad that you didn't know. That's not a good excuse. Folks, you're watching Legal Talk, brought to you by O'Donnell, Weiss and Megay Law Offices. Jim Kovaleski and I are talking to you about commercial lease terms. Please stay tuned for a bunch of words from our sponsors, and for the second half of the show, where we'll talk more about commercial leases. Thank you.
How would you build the perfect bank? Would you put it close to your home or your work? Would you make it a high-tech wonderland with web banking and 24-hour access? Or a hometown bank with tellers who know your name? If you could build your perfect bank, it might look a lot like National Penn Bank. Convenient branch and ATM locations, innovative technologies for 24-hour access, attentive personal service, and free checking with no minimum balance or monthly account fees. It's all right here at National Penn Bank.
There are many reasons people join AAA and renew their membership year after year. In addition to the peace of mind of emergency roadside service, AAA membership includes expert travel planning, exclusive discounts, and more. AAA members also get exclusive Show Your Card and Save discounts at participating retail merchants and can save money on theme park tickets, luggage, and travel accessories at the East Penn Travel Store. Join today and start taking advantage of all AAA East Penn has to offer. And visit us on the web at www.aaa.com.
Hey, welcome back to Legal Talk, the talk show brought to you, by your law firm, O'Donnell, Weiss & Mattei Law Offices. We're in Phoenixville and Pottstown, and our website is owmlaw.com. I'm Dave Megay. I'm joined by my partner, Jim Kovaleski. And folks, if you're just tuning in, we're talking about commercial leases, and it doesn't matter whether you folks are landlords or tenants or thinking about becoming landlords or tenants. We're talking about commercial leases and the terms that we need to be vigilant and cognizant of when we negotiate these things. And Jim, we're talking about everything from your basic retail space, storefront space, to large commercial spots.
Yeah,
the second half of the show, Jim, let's talk about, we tackled about 4 or 5 issues in the first half. Let's hustle and get through about 4 or 5 issues on the second half. And the first thing I want to talk about is fit out. And I mentioned it, I think, briefly at the top of the show, first half of the show. Fit out and landlord work, tenant work, and give the viewers an idea of, if you're coming at it from a tenant standpoint, what you may want the landlord to do for fit out or for work-wise.
Absolutely. I mean, if you're looking at it from the tenant perspective, you want the landlord to do as much as possible potentially for you, meaning that if usually I'm dealing with fit out in new spaces, so it's under construction or maybe it's recently completed. Landlord's looking, you're probably the first tenant maybe in this space. So you want the landlord to build out those walls, to bring it to a shell format, which is basically plain walls. You know, you pick out the carpet or the flooring, and then you have the ability to then go in and customize that space. Sometimes the landlord will do that second part of customizing the space. Sometimes they don't want to. Sometimes you bring in your own contractor. When you're doing that, you're also looking at, is there any fit-out allowance where the landlord's giving you a certain number, a certain dollar amount per square foot to help you, assist you with that fit-out.
Yeah, that's if the landlord says, look, we're not going to do anything other than we'll pay for the first 100,000. So at whatever $1,000 square feet, that'd be fit-out allowance of X dollars a square. I lost my.
100.
There you go. There you go. I lost my math. But anyway, you get my point. So the landlord may say, well, we'll pay for the first X. Anything over and above that, we'll do, but it's going to be at your cost, tenant, and we'll amortize that payment back as part of your lease over X number of years.
Absolutely. And depending on the type of tenant, that fit out can be a very big number. Like I've done some medical office leases, and they're going to be a lot larger than, say, someone that just needs a bare bones office with a little conference room or something like that.
And the landlord could give you better terms than a local bank could.
Yep, absolutely.
But they're going to want a longer term and longer commitment from you if you're the tenant.
Absolutely, and that's all part of the negotiation.
Right. So it's very important, folks, if you're a tenant or a landlord and there is some some fit-out issues, you want to have an exhibit with tenant's work. This is what the landlord and the tenant expect the tenant to do, X, Y, Z. And then the landlord's work. The tenant can expect that the landlord is going to do the following items before the tenant's rent obligation starts. And we negotiated that as well. It's a little esoteric, but I've negotiated where the tenant's obligation to pay minimum rent does not start until the landlord's work is substantially completed.
Absolutely. So
you have a lot of moving parts there
Yep.
that need to be negotiated with the help of your attorney, folks. Also, Jim, I think it's really important that, especially in new space, now if it's existing space, not so much, but if it's brand new space that's still being constructed, it's very important that we have as an exhibit to the lease a schematic, is that the term, or a diagram of the tenant's leased premises. X feet by Y feet, and it's all laid out. So there's no misunderstanding as to what's going to go where, because I've had that before.
Absolutely, because that gives you two things. It gives you where everything's going to go, but it also helps determine the amount of square feet that you're renting.
Yes.
So, which all factors into the amount of rent. And on that thought, one thing that we didn't talk about beforehand, Dave, that just popped in my brain is, if you are renting new space and it's under construction, so you can't immediately take possession of it, I like to negotiate for the tenant an out clause, meaning that if something happens to the landlord and their workers go on strike or whatever the case may be, if they can't deliver that space by a certain date or drop dead date, maybe they get a little bit of an extension, but after that, then the tenant has the right to walk away, because the tenant's probably chomping at the bit to start their business.
Yes, I had a situation like that 5 or so years ago out of Limerick, and we signed a lease, and it was new construction. In fact, they hadn't even broken ground yet. And we had put in there a drop-dead date that possession must be delivered by the landlord, substantially completed to the tenant by, say it was 6 months after we signed the lease. And we got to 5.5 months later, and I don't know that they had actually even broken ground yet.
Oh, my gosh.
It was bad news, yeah, it was real bad news, because unfortunately the tenant had already advertised coming soon, had already put their brand out there. That it was coming to this particular spot, and he had to walk that back. But we had an out from the lease, because the landlord didn't make that drop dead date. It's very important, because otherwise, 5 years later, we could still be waiting for this thing to be constructed, and we'd still be bound by we meaning the tenant, bound by the lease. That's a great point. Jim, let's talk next about signage and how we're running short on time, but how extremely important signage is to get into that lease.
It is. It's important to understand what the lease permits, and you want to negotiate in whatever you want in there. So if you want part of the marquee sign, if you want something on the building, if you want the ability to sometimes even put signs in the windows, because some of the leases say you can't do that, you've got to be very specific as to what is permitted in the lease and make sure it's in there. What the other part of that negotiation is to make sure whatever the township or borough permits for the signage at the building. So you might even want to look into that, or have the attorney that you're working with look into that, so that you understand what you can, and then what you want might be based upon what you can do.
That's really important, the signage thing, because folks, if you're the tenant, don't assume that you as the tenant in the shopping area is going to get a guaranteed space on the pylon sign down out at the roadside. I had a situation in North Coventry years ago where we didn't assume that. We demanded top billing on that pylon sign along Route 100. A couple of years into it, the tenant had an opportunity to lease a lot of space in that shopping center to a big box store, and the landlord just said to us, "We're going to be moving your sign," and we said, "No, you're not. Nope, time out," because at paragraph so and so the lease gave us top billing in that pylon, so we had them. Next, Jim, and we're really short on time, grace period. I'm checking my little notes here. Grace periods are real important, folks. Do the first of the month. Do the first of the month. You want to build in a grace period if you're the tenant. If you're the landlord, you want to lock that grace period in as short as possible and build in a late fee as well.
Yep.
What about legal fees in the lease?
Absolutely. With legal fees, I look to include language that basically says that either party can get legal fees if the other party breaches. So if the landlord does something that they're not supposed to, the tenant needs to sue them under their lease for a breach. The tenant gets legal fees, or vice versa. If the tenant does something bad, landlord has to chase after them. The landlord would be entitled to it.
Yeah, and if you're the landlord, folks, you want to make sure that that lease provides that if the tenant defaults, you get late fees, finance charges, and legal fees. And if the lease is silent, you're not going to get the legal fees.
Yep.
So if you're the landlord, make sure it says that the landlord gets legal fees from the tenant if the tenant breaches. You can put a period there and hope that Kovaleski doesn't represent the tenant, because if he does, he's going to want to make that attorney fee provision mutual, which is only fair. If the landlord breaches, the tenant gets their legal fees paid. If the tenant breaches, the landlord gets their legal fees paid.
Yep.
Jim, in the next 4 minutes, I'll give you 4 minutes to talk about two really important issues, folks, and that is confessions of judgment and personal guarantees. You're not going to see confessions of judgment in residential leases, but you are in commercial leases. And if you're the landlord, you want them in there. And if you're the tenant, you don't want them in there. What do you think?
Absolutely. I mean, Pennsylvania is one of the few jurisdictions that still allows for confession of judgment. What that basically means is that there's usually 2 paragraphs, one dealing with financial damages, one dealing with possession of the property. Ejectment is sometimes referenced as. If the confession of judgment is in there and the tenant breaches, what it allows the landlord to do is basically walk down to the courthouse, file some paperwork, get a judgment for those damages that the landlord claims are due, and to get a judgment that says that the tenant is ejected or must remove themselves from the premises. That's all without filing a complaint, which then gets served upon the tenant. Then the tenant has a certain amount of time to answer it.
Right.
There's preliminary objections, and then 6, 9, 10 months, 12 months, whatever.
Or more.
Or more, depending on the county. Later, maybe the landlord gets the judgments that they want. So confession really shortens that time period and gives the tenant less ability to respond or to object to it. So that's why the landlord wants it, because if you miss your rent payment, it's due on the 1st of the month. On the 5th of the month, they want to be able to walk into the courthouse, file confession of judgment for that damages, and to get one for possession so they can kick you out. With the tenant, like Dave said, you want to try and negotiate those out. Oftentimes, maybe reach a mutual negotiated position where the damages goes away, but the possession stays in. But it really depends, again, on the facts and circumstances of each case.
Right, and the confessions of judgment, as Jim intimated or specifically stated, that if you're the tenant and you grant confession of judgment for possession or money, you are waiving, for the most part, your right to defend yourself. You're waiving your right to say, hey, wait a minute, I'm not in default, or okay, I owe you money, but not as much as you say I owe you. So you're waiving those rights for the most part, and you're waiving your right to defend yourself in court, because then the landlord can get a judgment against you right away. Mm-hmm. Most landlords are going to insist upon both confessions, but as Jim mentioned, you can try to negotiate them away, or negotiate perhaps the confession of judgment for money, get rid of that, to retain for the tenant the right to defend themselves on how much is owed. But for possession purposes, if I'm your tenant and I'm not paying, you want me to heck out of there.
Absolutely.
So that you can get somebody else in, but then you and I will duke it out later on how much I owe you.
Absolutely.
So folks, keep an eye on those two items: confessions of judgment for money and confessions of judgment for possession. Last thing I want to talk, before I forget, on those issues, that gets back to what we said a minute ago. It was a good segue from the whole grace period issue
Absolutely.
to the confession. So if you're the tenant and the landlord insists on confessions of judgment for money and possession, and they won't budge, you're going to accept probably the lease spaces. You probably aren't going to blow up the deal over that. But you want to make sure that you have an adequate grace period to pay that lease or rent, and you want to have an adequate cure period. If you default, you want the landlord to give you written notice and give you X number of days to cure your default. In other words, to pay the rent that you owe, albeit with late fees, maybe even attorney's fees. The landlord's going to say, okay, fine, but you can only do that once a year, twice a year, once a year, but if you do it 3 times, then you're done, something like that.
Yep.
So I wanted to throw that in there. Last thing, we got a minute, Jim. Personal guarantees, and this is a good way to tie the room together, as they say, because the first thing we talked about is who's the name of the tenant. Is it a corporate tenant or is it a personal tenant? If it's a personal tenant, we don't have to worry about the personal guarantee, do we?
No, because they're already personally obligated on their lease as the tenant.
Right, but what if the tenant is a corporation?
If the tenant's a corporation and I represent the landlord, of course I want the personal guarantee of usually the owner of the corporation. Most small businesses are owned by one person, and I usually want to even get that person, if it's a husband or wife, to get their husband, their spouse, to also personally guarantee it.
Yeah, but wait a minute. My spouse has nothing to do with my business, Mr. Landlord or Mr. Landlord's counsel.
Oh, I understand that, but I'm sure that you and your spouse probably own everything jointly as husband and wife, so there's some protections that type of ownership affords, and I don't want to have to deal with those type of protections. I want to make sure that I have both of you on the hook, so any assets that you own, either individually, your spouse owns individually, or you own as husband and wife, are all subject to the judgment that I could potentially get under the lease.
Okay. All right, folks, we're out of time. We could talk, Jim and I, for another hour or two. You've been watching Legal Talk, brought to you by O'Donnell, Weiss, and Megay Law Offices. Your life, your business, your law firm. We're at www.owmlaw.com. Give us a call if you're a landlord or tenant in a commercial setting. We're more than happy to help. Thank you and have a great night.